And now we get to hear from Judge Kacsmaryk, and I want to say a few words in introducing him. Judge Kacsmaryk serves as a U.S. District Judge for the Northern District of Texas. And if you were in law school when he was here at the University of Texas, you would found him at the Federalist Society or at the Texas Review of Law and Politics, where he worked as an executive editor. He then went off to Baker Botts and worked in private practice. Then he worked at the DOJ as an assistant U.S. attorney working on sensitive national security matters and FISA matters, and was recognized by the Attorney General in 2013 with the Attorney General's Award for Excellence in furthering the interests of U.S. national security. And as a public interest lawyer, I also love that he spent time working on public interest constitutional cases at a nonprofit, First Liberty, working on appellate work and Supreme Court level work. All of that experience benefits everyone when he brings it to the judiciary. And we get to hear from him today. So please, let's welcome Judge Kacsmaryk.
So let's be honest, if it was a Trollp Blue Book session, I probably wasn't there for that. Okay, so welcome to day 2 of the 2025 Texas Chapters Conference. Today's panels are loaded with subject matter experts and topics ripped from the headlines. Panel 1, DOJ and the Deep State. Panel 2, Educational Freedom Inside and Outside the Public School. Panel 3, Business Court and the Texas 15th Court of Appeals. Your moderators and panelists hail from the private, government, and nonprofit sectors, including, for any law students looking for employment, federal judges from the Fifth Circuit and the Eastern District of Texas, staff attorneys from the Texas Attorney General, Institute for Justice, ADF and Beckett, and state judges from the Texas Supreme Court, 15th Court of Appeals, and Business Court. So please stay tuned. Now, for opening remarks. Because I previously served as counsel to a nonprofit focused on First Amendment litigation, but also as an AUSA who worked on terrorism cases, my remarks focus on the intersection of free speech and law enforcement in the aftermath of Charlie Kirk's assassination and the political violence summarized in Vice President J.D. Vance's recent podcast. But not to reiterate the heartfelt entreaties to civility, dialogue, and discourse, which rightly appeal to the better angels of our nature, and not to repeat the boilerplate on the marketplace of ideas, which should always be open to people of goodwill who peaceably assemble to speak words. Those sermons are very necessary, but they're not sufficient to explain the atomization, tribalism, and subjectivism underlying leftist political violence reminiscent of the syndicalism movement in the early 20th century and the days of rage, carnage of the 1970s. A deeper inquiry reveals at least 3 issues underlying the current carnage and chaos. First, to better understand this 21st century moment, we must understand the truth decay, eroding the shared reality necessary to sustain our civil religion, as that term is variously defined by sociologists like Robert Bellah. Second, to defend the Constitution using textualist tools, we must untether the free speech clause from a late 20th century expressivism that bears little resemblance to the First Amendment written, ratified, understood, and enforced for over 160 years. And third, to combat domestic terrorism, the free speech clause must be read using the same text, history, and tradition textualism applied to other amendments and clauses, with an eye towards the historical application of law enforcement to organized crime, conspiracies, and terroristic threats. So we're going to try to do that all in 15 minutes. First, regarding truth. So when combined, Carl Trueman's 2020 book and Richard Epstein's 2016 Law Review article explain why 21st century Americans struggle to identify truth in a postmodern era. In his 2020 magnum opus, The Rise and Triumph of the Modern Self, Professor Trueman recounts the 300-year intellectual history that culminated in what he calls the therapeutic self. In summary, Western man oriented himself to a mimetic, external, and objective reality discerned by trusted authorities. But therapeutic man orients himself to a poietic, internal, and subjective reality decreed by the almighty self in service of whatever my truth narrative is consistent with emotions generally associated with happiness. If a fact, concept, or argument elicits happiness, then it's my truth. If a fact, concept, or argument elicits unhappiness, it must not be true. And in fact, it must be ignored, restated, purged, or even killed. Consequently, a culture of therapeutic selfies quickly descends into a war of all against all, where power decides who is right and who is wrong, who is safe and who must be silenced. Now, Richard Epstein described a similar strain of subjectivism in a 2016 article published in the Harvard Journal of Law and Public Policy, the flagship law review of this organization. It was entitled Linguistic Relativism and the Decline of the Rule of Law. Therein, Professor Epstein argues that, quote, linguistic coherence is a minimum condition for the rule of law. And he went on to decry fashionable theories of language that reduce words to mere pluripotent goo. Words like property, contract, coercion, and harm are deconstructed until all that remains is pliable silly putty, manipulated to match whatever modality matters most to the practitioner or even the jurist. Even worse, this relativistic process of linguistic deconstruction can actually invert the ordinary public meaning of long-standing words like coercion and harm. And he used the Masterpiece case as an illustration, where the coercive commission charged Jack Phillips with coercion. We see these dark tools at work in the aftermath of Charlie Kirk's assassination, as partisans masquerading as journalists start with the narrative and then backfill with misstated facts. So, cheery start to the morning. If the therapeutic self exalts my truth falsehoods in service of subjective emotions, and jurists use linguistic relativism to misread, misstate, and even rewrite the ordinary public meaning of fixed words, how do we reclaim the public square and restore the objective comity and charitable discourse necessary to sustain our constitutional system? A republic, if you can keep it. Yes, various tools of originalism, textualism, corpus linguistics, canons, and more Scalia-Garner treatises will assist lawyers and jurists arrive at a better and better ordinary public meaning. But these tools are not fail-safe, even in the judiciary, where we are reportedly all textualists now, but the Bostock case produced 3 different textualist readings of the same statute, which was only enacted in 1964. Instead, we must consciously purge the lesser angels of subjectivism and relativism that cause both right and left to exalt falsehoods, and begin to recover a shared commitment to seeking external objective truth, even though that is a mere aspirational goal and hard to achieve, especially when the external objective truth requires nuance. I do not mean the nuance that's peddled by politicos too broad-minded to take their own side in a quarrel, where it's just a lazy synonym for the truth must lie somewhere in the middle. No, I mean nuance as historically defined, maybe in Webster's second dictionary, which was Scalia's favorite. Quote, sensibility to, awareness of, or ability to express delicate degrees of meaning, definition, or value, because that is often where the truth of the matter resides. The goal is admittedly aspirational, and our civil religion is strained in this moment, but we should aspire to that. So next, on expressivism. So in his 1983 book, Statecraft as Soulcraft, George Will famously argued that the most important 4 words in politics are up to a point. For about 160 years, First Amendment jurisprudence echoed a very similar and classical vision. Free speech, press, petition, and assembly rights combine to protect and elevate the public discourse necessary to self-government, but only up to a point, as states continue to exercise their historical police power to regulate health, safety, and morals. And as late as 1957, the Supreme Court held that, quote, the unconditional phrasing of the First Amendment was not intended to protect every utterance. Citing Chaplinsky's fighting words test, the court explained in Roth versus United States that mere expression may not suffice in all instances. Quote, it has been well observed that such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Thus, for 16 decades, the free speech clause harmonized disparate and competing interests using text, history, and tradition as guideposts, sometimes along a sliding scale. Political speech is different than commercial speech. Pornography is different than obscenity. Viewpoint is different than content. And with forums, the traditional is different than the designated is different than the limited forum. And at all times, overriding all of this analysis, the court recognized distinctions between thought, speech, and conduct. Free speech, but up to a point. But beginning in the 1960s, free speech jurisprudence absorbed a new civil religion of expressive individualism, as recounted in David Lowenhall's book, No Liberty for License. And almost overnight, the court constitutionalized conduct deemed regulable for centuries, as the long-recognized distinction between thought, speech, and conduct merged into a new catch-all category not referenced in the clause itself, expressive conduct. Today, this transition from a classical to expressivist free speech rule has reached its terminus. The free speech clause that once paired with press, petition, and assembly to elevate public discourse and the unfettered exchange of ideas, even ideas deemed unorthodox, controversial, or hateful, now protects streakers but not speakers at UC Berkeley. Puppy crushers, pornographers, cross burners, flag burners, Nazis taunting Holocaust survivors, and fraudsters who claim they won the Medal of Honor. No longer a clause read alongside the rest of the Constitution up to a point, or weighted on the scales of text, history, and tradition applied to other amendments, contemporary expressive conduct jurisprudence reaches far and wide. Yet, the promised maximalist free speech culture never materialized. In archetypal marketplace of ideas forums like social media or the college campus, where so-called cancel culture is most pronounced, most pernicious, and in Charlie Kirk's case, most lethal. So what went wrong? If Americans and members of this Federalist Society wonder how and why this happened, we could start with a text, history, and tradition textualist review of an inverted First Amendment jurisprudence that constitutionalized some conduct once deemed regulable while simultaneously failing to protect the core political speech once deemed inviolable. Now, as a former AUSA, I do want to address the issue of law enforcement, as this is tossed back and forth in the current debate. When I moved from the Department of Justice to the nonprofit sector, I encountered a strange but recurring species of free speech absolutists who sincerely believed it was unconstitutional alchemy to convert words into evidence in a criminal case. You're criminalizing free speech, the very core of the First Amendment. But time and again, further analysis revealed three unspoken and mistaken assumptions baked into an otherwise righteous zeal for America's favorite amendment. First, as former AUSA Andrew McCarthy explained in a recent article, the words, make him an offer he can't refuse, are free speech in an innocuous context, but can also be used as evidence to prove criminality if connected to unlawful conduct. And I'm quoting here from Andrew McCarthy. If you ever want to know about criminal law, the DOJ, and its intersection with the Constitution, read every word written by Andrew McCarthy. We know this intuitively, and it is a bedrock principle of criminal law. The First Amendment prevents the government from criminalizing speech itself. It is not a crime to utter words. It prevents the government from criminalizing the mere gathering of two or more people. Mere association is never a crime. Nevertheless, if a person is credibly accused of crimes like extortion, for example, there is no legal prohibition against using speech as evidence of those crimes. And if a person is credibly accused of conspiracy, there's no legal bar against presenting the conspirators' association with each other as evidence that they were joint participants in a criminal agreement. Second, an incorrect assumption that the First Amendment always wins, even when balanced alongside other amendments and other constitutional provisions. When you're a hammer, everything looks like a nail working in the nonprofit sector. But a quick survey of criminal law reveals that other amendments routinely prevail in the balance. The Sixth Amendment right to speedy trial and impartial jury predominates in many high-profile criminal cases. as illustrated in the famous Shepard and Stewart cases where gag orders were deemed constitutional. Fourth Amendment analysis predominates in search and surveillance cases, not the chilling arguments that sound in a free speech clause argument. And in national security division cases, the Supreme Court has consistently affirmed the Foreign Intelligence Surveillance Act statute and its court structure, notwithstanding significant and erudite First Amendment challenges that date back to the 1970s. The third incorrect assumption about criminal law, that federal law does not criminalize threatening words. Now, this is true, but again, up to a point. As too many Article III judges know at a personal level, and district judges who serve in the Northern District of Texas know all too well, the United States Code criminalizes, and the Supreme Court has affirmed, several true threat categories where speech is, if the speech is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. I'm of course quoting Virginia versus Black in cases applying it. For all these reasons, First Amendment practitioners who never practice criminal law often overstate the free speech restrictions on the FBI or the DOJ, who are faithfully and lawfully investigating speechy crimes like extortion, racketeering, conspiracy, fraud, terrorism, and terror financing. I know because I worked on those cases. Until further notice or evidence to the contrary, that's probably what the Department of Justice and the FBI are doing now, notwithstanding any misstatements about hate speech. So, in conclusion, I'd like to quote Margaret Thatcher. So after a series of hijackings and bombings, British Prime Minister Margaret Thatcher famously implored, "We must find ways to starve the terrorist and the hijacker of the oxygen of publicity on which they depend." As 2025 feels more and more like 1969, should we use our podiums to preach, "More oxygen, please"? Or should we use this podium and our free speech to openly debate ideas with the goal of learning the truth and defending those who are provably of goodwill and committed to using words only, while also using this podium to denounce those who would do physical violence and particularized threats targeting particularized people, specifically denouncing those who would do physical violence to truth tellers. I think that is what the moment requires. So with that, you'll be on to your next panel.